Have you ever pondered upon the question, what is the philosophy behind law and how it shapes our society? Welcome to the intriguing world of jurisprudence, a realm where law and philosophy intertwine to give us insights into our legal structures and societal norms. Jurisprudence, often described as the philosophy of law, is a field that explores fundamental questions about law, justice, morality, and their role in society. The term jurisprudence finds its roots in Latin, where juris means law and prudentia signifies knowledge or skill. Together they represent the knowledge or the study of law, but jurisprudence is not merely about learning the law, it's about comprehending the principles that guide its creation and application. Imagine jurisprudence as a vast ocean and the laws as the waves. Just as an oceanographer studies the characteristics of waves to understand the ocean's depth, a jurisprudent delves into the intricacies of legal rules to comprehend the depths of societal values and principles that shape our legal system. Jurisprudence plays a pivotal role in understanding and interpreting the law. It helps us to look beyond the written words of legislation, to explore the underlying principles and concepts. It aids in comprehending how the law has been shaped by societal values and how it continues to evolve with changing times. This understanding becomes a vital tool for legal professionals, enabling them to interpret and apply the law effectively. But its significance extends beyond the realm of legal practice. For all of us as members of society, understanding jurisprudence can help us appreciate the law's role in maintaining social order, promoting justice, and safeguarding our rights and freedoms. In the upcoming sequences, we will be delving into the different types of jurisprudence, each with its unique perspective and approach to law. We will explore how these diverse schools of thought have contributed to the evolution of our legal systems and continue to shape our understanding of law and justice. Dive in with us as we explore the different types of jurisprudence, each with its unique perspective and approach to law. Imagine a world where moral and ethical codes determine the law. Welcome to the realm of natural law theory. Delving into the roots of natural law theory, we find ourselves in ancient Greece with philosophers like Aristotle and Plato, who believed that there existed a higher, natural law that transcended human-made laws. Fast forward to the medieval period, and we see this theory being further developed by thinkers like Thomas Aquinas, who posited that laws that didn't align with the moral order were not true laws at all. At its core, natural law theory asserts that certain rights and values are inherent by virtue of human nature and universally cognizable through human reason. It's not about what the law is, but what it ought to be. This theory proposes that laws should reflect moral and ethical codes, and if they don't, they are not just laws. Let's illustrate this with a hypothetical situation. Suppose a law is passed that allows for discrimination based on ethnicity. According to natural law theory, this would not be a valid law as it infringes upon the inherent human right to equality. Now, consider another scenario. Imagine there's a law that prohibits theft. Natural law theory would deem this as a valid law as it aligns with the universal moral understanding that stealing is wrong. However, it's important to note that this theory is not without its critics. Some argue that the concept of a higher law is vague and subjective, and that it can be manipulated to justify almost anything. Others point out that it doesn't adequately address cultural relativism, as different societies may have different moral and ethical codes. Regardless of its criticisms, natural law theory has had a profound influence on the development of legal systems worldwide. It has shaped constitutions, human rights declarations, and legal principles that we see today. Natural law theory, where morality and law intertwine, offering a unique perspective on jurisprudence. What if laws were merely social constructs, devoid of any moral or ethical considerations? Enter legal positivism. Legal positivism is a school of thought in jurisprudence that maintains that the existence and content of law depend primarily on social facts and not on moral considerations. It's a perspective that views law as a human creation, a product of human decisions and actions. The roots of legal positivism trace back to the 19th century with the works of legal philosophers like John Austin and Jeremy Bentham. They argued that laws are commands made by a sovereign and backed by sanctions, independent of ethical or moral considerations. Now let's break down the main tenets of legal positivism. First, it posits that law is a set of rules made by human beings. Second, there's a clear distinction between law as it is and law as it ought to be. In other words, the existence of a law does not mean it's morally right or just. Third, the law is a social phenomenon and its validity doesn't depend on morality. Now you might wonder how legal positivism manifests in real-life situations. Consider a scenario where a law is enacted that some people find morally objectionable, such as a law limiting certain freedoms. A legal positivist would argue that whether or not the law is morally right or wrong doesn't matter. What matters is that the law exists, and it must be obeyed. However, it's important to note that legal positivism is not without its critics. Many argue that it's impossible to separate law from morality entirely, and that laws should reflect the moral values of the society they govern. Despite these criticisms, legal positivism remains a dominant theory in the world of jurisprudence. It's a perspective that forces us to question our assumptions about the nature of law and its relationship with morality. Legal positivism, a theory that fuels the debate on the separation of law and morality. Ever thought about how the personal beliefs of a judge can influence their decisions? This brings us to legal realism. Legal realism is a school of thought that emerged in the early 20th century, primarily in the United States. The realists were a diverse group, but they shared a common belief that law is not a set of abstract rules, but something that is deeply influenced by the social and personal context in which it operates. In the heart of legal realism lies the understanding that law is not simply a matter of black and white. Rather, it's a vibrant spectrum of gray, influenced by a multitude of factors. For realists, the letter of the law is only part of the story. The way it is interpreted and applied by judges who bring their own experiences, prejudices, and beliefs to the bench is equally significant. Legal realism challenges the traditional view that judges merely apply the law as it is written. Instead, it proposes that judges make the law through their interpretations and decisions. The realists argue that judges are influenced by their personal and political beliefs, their understanding of social realities, and their perception of justice. To illustrate this, let's consider a hypothetical case. Two individuals are in court over a property dispute. The law in question is ambiguous and could be interpreted in different ways. A judge who comes from a wealthy background might interpret the law in favor of the property owner, believing in the sanctity of private property. On the other hand, a judge from a less privileged background might be more sympathetic to the tenant and interpret the law in their favor. This is not to suggest that judges are arbitrary or biased, but rather that their decisions are influenced by their unique perspectives and experiences. And it's this human aspect of the law that legal realism illuminates. In conclusion, legal realism is a theory that challenges us to look beyond the written law and consider the human element that invariably shapes its interpretation and application. It reminds us that law is not an impersonal set of rules, but a living, breathing entity that is shaped by those who interpret and apply it. Legal realism, a theory that brings to light the human element in the law. As we navigate through the labyrinth of law, it's essential to revisit the theories that guide our understanding. So let's take a step back and recap the fascinating world of jurisprudence and its types, which we've delved into today. First, we dove into the timeless philosophy of natural law theory. We learned that this theory holds a belief in a set of moral and ethical principles that are inherent in human nature and universally applicable. It posits that these natural laws should guide the creation and interpretation of man-made laws, a concept that has been influential in shaping legal systems throughout history. Then we shifted our focus to legal positivism. A contrast to natural law, this theory asserts that laws are rules made by human beings and that their validity is not dependent on any higher moral or ethical principles. This perspective allows for a clear distinction between law and morality, emphasizing that laws are valid simply because they are enacted by the legitimate authority. Our exploration then took us to the realm of legal realism. This theory pushes back against the idea that legal decisions are solely based on statutes or case law. Instead, it proposes that judges and other decision-makers are influenced by a variety of factors outside the law, including their personal beliefs and societal trends. This approach encourages a more practical and less formalistic view of the law. So, there you have it, a whirlwind tour through the rich and diverse landscape of jurisprudence. Each theory, natural law, legal positivism and legal realism, offers a unique lens through which to view and understand the complex world of law. Understanding jurisprudence and its types helps us comprehend the law better, an essential tool in our pursuit of justice and fairness.